Is there anything that we need to talk about at this time before we bring the jury in on behalf of the people?
Your Honor.
On behalf of the defense. Ms. Brady?
Yes, Your Honor. As the court's aware, the court issued an order to the parties that the parties are not to tweet via Twitter during the trial in court. And it came to our attention last night that Mr. Brauchler issued a tweet at 4:51 p.m., which would have been during the cross-examination of Dr. Reed. If I can approach, I'd like to give the court a copy of that tweet.
Yes. Have you shown it to Mr. Brauchler?
I'll give him a copy.
Okay.
If we could mark that as a court's exhibit, please.
Yes. What number are we up to?
46.
46. Thank you.
And Your Honor, I assume the court issued this order for a good reason, so I will leave it up to the court's discretion what sanction to impose for this violation. I would state, though, that if the prosecution is seeking the execution of a man, perhaps the district attorney should pay attention to the cross-examination of the mental health expert instead of chatting on social media.
Do you want to read for the record what the message or the tweet states?
It states on June 4th, 2015 at 4:51 p.m., I agree on the video. I hope the jury thinks so too.
All right, Mr. Brauchler?
Your Honor, first, I apologize for how this happened, but I want to explain I was not on social media at the time. I'm not sure how it all connects in, but I got a text. It was from a direct message, and this has happened to me accidentally before. And someone had just simply made a comment that I thought I was replying to on text. And as soon as we left court, Mr. Orman told me, hey, that reply went out all over Twitter. And then I quickly deleted it, and it doesn't exist anymore. I think it was on there for less than 20 minutes. Having said that, and again, I was not attempting to be on social media or do anything on social media, and I haven't violated the court's order since it came up. But having said that, the steps that I've taken are to turn off my phones and just instruct people that if I need to do any business while I'm in court, that they would let me know through other means. And Judge, it's an embarrassing mistake, but one that I think I corrected quickly and have put myself in a position to not violate again, and I'm sorry.
Ms. Brady?
Judge, I would note that before the correction, it was retweeted at least 3 times. We had found at least 3 times that tweet went out from other people. So as the court knows, once it gets out there, it spreads exponentially. And I just think, Dr. Reed was a pretty important witness, and the prosecution should be paying attention to the cross-examination of the witness.
And that's the problem with tweeting something, is that you don't know who's going to retweet it. And even if you tweet it, or you think you're only tweeting it to one person, that person can then retweet it to everyone else. I did call the parties, the attorneys, I should say, to the bench. It was about 4 weeks ago. I'm just estimating. And I specifically said I don't want anyone sending tweets from the courtroom about anything. But obviously much less about the case, although I didn't specify about the case. I just said about anything, and I think I explained to counsel at the bench that I have prohibited the media from tweeting from the courtroom, and I didn't think it was appropriate then for attorneys to be doing it, especially when proceedings are ongoing. We're not even talking about during breaks, but during actual court proceedings. There's nothing that can't wait until a break or until after court to be tweeted. And sometimes people develop habits, and sometimes they tweet things. I don't have any reason to disbelieve what Mr. Brauchler is saying, and so I'm going to take him at his word that he didn't intend to send this as on Twitter, and that he thought it was a text and that this was an inadvertent mistake. And I appreciate him apologizing to the court, but even texting, it seems to me it's something that really should wait until the proceedings are not ongoing. I don't know why email or text can't wait until a break, especially when it's your witness who's testifying and is being cross-examined. So I'm going to prohibit the parties from texting from the courtroom during proceedings. While proceedings are ongoing, counsel should not text. So they should be paying attention to what's happening here. Nobody should be texting, nobody should be emailing, nobody should be reading any electronic communications or sending electronic communications. If you're bored, and I realize that there are 5 attorneys on each side, and sometimes attorneys don't have any witnesses to question, if you're bored and don't want to pay attention to the proceedings, then you're welcome to leave. You don't have to be here. I don't need 5 attorneys on each side. I think I've talked about this before. I don't know that you need 5 attorneys on each side. So if there are attorneys who feel bored, then you don't have to be here. You're welcome to leave. But I think out of respect for the court, when you're in here, you should not be texting or tweeting or doing anything like that. You should be paying attention to what's happening here. So I'm not going to take any action at this time. No action has been requested of the court. Ms. Brady wanted to bring it to the court's attention. We've marked the communication as an exhibit, as a court exhibit, and so it has been marked. I have accepted Mr. Brauchler's apology, and I appreciate his candor. But let's avoid it from here on out. All right?
Yes, sir.
Ms. Tisch-McGuire.
Your Honor, I was just going to ask for an exception both for the defense and the prosecution for the sole purpose of just getting witnesses outside the courtroom, just because some of the advocates that are bringing witnesses here only have access to texting on a cell phone. I just wanted to ask for that one exception.
That's fine.
Thank you, Your Honor.
If it's related to that, I understand, and I get that there are a lot of witnesses in this trial. I get that the magnitude of this case requires a lot of logistical arrangements and planning, and so if it's related to that and you have to email someone or text someone and it's related to scheduling or related to witnesses or related to something you need, I understand that, but that shouldn't take very much time and it shouldn't be with a whole lot of frequency. So, but if you're just texting or emailing about what you think or what's going on or other things that are unrelated to the case, that's different. And I understand Mr. Brauchler is the elected district attorney of this judicial district. I get it. I'm the chief judge of this judicial district, but you know, I managed to stay off email and text, certainly text. I don't even have my phone here with me on the bench. So if I can stay off of electronic communications for the most part, then so can you, so can everybody here. Again, there are exceptions. There may be situations where for logistical reasons or scheduling reasons or reasons related to witnesses or an emergency, you need to do that. And I've done that a couple of times, but it has to be rare, extremely rare. So, okay,